public policy issues raised by the case and legal issues. And the question really is, and we don't know the answer to this, is Enron an Enron problem, or is Enron a bigger problem, a systematic problem, a problem of the system in some ways that has to be answered? And while the newspapers, reading the press, and Congress will make you think it's a bigger problem, it may in fact be a big problem. But we don't really know yet. But we want to raise some of the issues raised by the Enron case. That's what we say from a legal point of view. And often big cases or big issues and big legal responses can come from these big issues. I mean, anyone who studied the securities laws knows that it came as a result of the stock market crash of 1929. And many people view it as a result of the crash of 29 was because of fraud, and a lot of issues that are raised in Enron to some extent. So we are going to talk about a variety of issues. The speakers are going to touch the surface. We're going to try to do it at a level that all of you can understand, because we know that some of you have not yet taken corporations or securities laws and some of those issues. The real thing we want to do is be able to have you ask questions. So we're going to try to get through it, as I say, before 5, and leave about a half an hour or so for questions from the audience. That's what we're hoping for. Okay?
First row is empty.
Yeah, I mean, if there's seats here. Don't be afraid. There's a handout, but there's no exam in the class. Thank Professor Ziegler for the handout, for the materials, etc. So you can come up. Don't feel fearful. Are you sort of ready, Ted?
I'm up. Yeah, let me just see if I can make this
up.
Yep, we're good.
All right. Professor Jenger is going to do something that is not easy to do. He's going to try to explain the fraud. Now, there are lots of potential frauds here, but he's going to try and explain at least one of the major frauds and one of the major causes for the demise of Enron. Okay? So go ahead, Ted.
Yeah, if you look in the handout, for those of you who can't see the screen, the first handout is a summary of the slides. Some of the numbers on there are a little small, so I will, and I'm sorry, I apologize for numbers. This is about money. I'm going to explain, actually, the two frauds that initially caused the run on the bank that caused Enron's finances to unravel. And in particular, what I want you to be able to see is how Enron used certain separate partnerships and entities to manipulate what its balance sheet looked like and to fool the stock market and, well, maybe its accountants and maybe not. The trick and the key to understanding what Enron did is that they basically took on debt and didn't tell anybody. Now, why is that a problem? Well, I hate to do this, but here's a little bit of corporate finance. If you're an accountant and you want to know what a company is worth, you do a balance sheet. And the balance sheet, it tells you how much the company is worth by putting all of the assets on the left side of the balance sheet and all of the liabilities on the right side of the balance sheet. So here you have a company, we'll call it Enron, with assets worth $1,400,000. Then there are various types. Then it's got a mortgage of $500,000 and accounts payable of $5,000. Total, $1 million. What's the company worth? $1,400,000 minus $1 million equals $400,000. Simple, right? Now, what happens if this company decides to borrow $500,000? I want you to watch two numbers as I flip the slide. The first number I want you to watch is the cash balance, which right now is $300,000 on the asset side, and the accounts payable balance, which right now is $500,000 on the liability side. Left side, right side. Now, they borrow $500,000. Watch, the cash number went up to $800,000. But note, the accounts payable number on the right side went up by $500,000 as well. As a result, the total assets went up to $1,900,000. The total liabilities, though, went up to $1,500,000, and This is the magic of being an accountant. Oops. The shareholder equity stayed the same at $400,000. The magic in running a company comes not from borrowing money, but from what you do with the money. Okay? The question was, if you take that $500,000 and make it worth more, then you affect shareholder equity. But the loan itself shouldn't. Now here's what Enron did. Let me go back. They borrowed $500,000 on the left side of the balance sheet, but they didn't put it on the right side of the balance sheet. So cash goes up by 5, but they don't put the $500,000 on the accounts payable side. And watch, a miracle happens that matters a lot to stockholders. Instead of having shareholder equity worth $400,000, you have shareholder equity worth $900,000. Now, the problem is, it's a lie. Now, put in these simple terms, it seems like a fairly obvious lie. So the question is, how did Enron use corporate entities and these partnerships that we've heard so much about to fool people? And what they did was that they took advantage of and stretched the limits of what are called the rules for off-book accounting. Now, imagine the following situation. Enron has an asset. Somebody owes them money. Let's do a simple one. Someone owes them $100 a year for the next 10 years. Over 10 years, that will bring them $1,000. But let's say that because money is worth more now than it will be later, that's really only worth about $700. And someone would be willing to pay them $700 for that income stream. And they want the money now. They can do one of two things. They can borrow money from a creditor. Say they borrow $700,000 from a creditor, and they could borrow it against the asset, and we see what happens on the left side and the right side of the balance sheet. On the other hand, what they could do is simply sell the asset for $700. And they can sell it to a separate entity. And that's the genius of what's called structured finance. Enron can sell that income stream to a separate entity, which in turn will turn around and borrow the money to pay for the money that it pays to Enron. So far we've got a perfectly legitimate transaction. Enron sells an asset, Enron gets the income. The benefit is it takes a slow-producing asset and turns it into cash now. And this works slightly differently on the balance sheet than the loan that I described before. This is a little bit hard to see, so I'll walk over and show you. Remember, if it was a loan, we had cash up on this side and debt on this side. When you do a sale, instead what they do is, let's say they sell some inventory. That used to be $500,000. What you've done is you've converted $500,000 in inventory to $500,000 in cash. The cash balance goes up, the inventory balance goes down. It all happens on the left side of the balance sheet, so there's no need to account for the debt. And note, equity stays the same. But what Enron was doing was playing the same games with asset sales that I've just described with a loan. By playing games with whether or not the sale was what we call a true sale, and whether or not the entity was in fact a separate entity. And here's, when I say a true sale, what I'm saying is that if the asset turns out not to be worth $700, that's the buyer's problem, not Enron's problem. Similarly, when I say a separate entity, I'm saying that Enron doesn't own the people that they sold the asset to. Well, here's Enron. Enron is a company. It borrows money, it has shareholders, and it has a bunch of businesses which produce income. And let's assume that it wants to do this bit of taking slow money and turning it into earnings now. So they set up a whole bunch of partnerships. I've just put one over here, but as we now know, there were hundreds of these things, or at least dozens of these things, and they sell assets to these special purpose entities. Now, here's the problem. Enron owns a large chunk of these special purpose entities, and under accounting rules, they're allowed to own up to 97% of the SPE and still treat it as off the Enron balance sheet. That's kind of remarkable in and of itself. That's legal. But Enron couldn't even make it with the 3% outside investment. Enron actually, for some of these entities, had to guarantee the outside investment. What does that mean? That means if the asset sold isn't worth what Enron promised it was worth, then Enron is liable. What does that mean? That means Enron should be booking debt on the right side of its balance sheet. But it wasn't. Similarly, they had one other thing that they did with some of these entities, which is they guaranteed themselves the value of the asset that they sold. So let's say that the income stream was worth, say, $700,000, but there's a risk of default. The person who owes Enron money might not pay. Well, what Enron would, if the buyer of the asset would say, well, look, we'll only pay you $500 for it, Enron would say, no, pay us $700, and if it turns out to go into default, we'll buy it back from you. What's that? That's undisclosed debt. So what Enron was doing was using these special entities to push debt off its balance sheet, and what you've just noticed is that they're inflating the value of the assets that they've sold. So that what happens is they book lots of stuff on here, and because of the rules for off-book accounting and because of the compliant nature of their auditors, they leave all this stuff off. That's what they did. And the result of doing this in two partnerships back in August, when Anderson figured it out, caused them to have to restate their shareholder equity. You know, that number, the $400,000 number we were talking about, by $1.2 billion.
Very good, Ted. Very good. And it drove the market price of the stock down and kicked in all kinds of debt.
Right. Well, lots of things. As the market price went down, a lot of the assets in these SPEs suddenly weren't worth as much as they were supposed to be, so the whole thing fed on itself and came unraveled.
Right. And it leads me to my subject. I'm Professor Pinto, and it leads to the subject of corporate governance and the issues raised by Enron in the corporate governance context. And really, if you think about, if you study corporate governance, it's really about trust in many ways. And what we see here is ultimately a lack of trust in Enron that drove it into bankruptcy to some extent. So what do we mean by corporate governance? Well, briefly, as many of you know, I mean, this may be somewhat basic, but the primary means that which our major businesses raise money is through the corporate form. And many of our businesses are what we call these large publicly traded corporations, the IBMs, the GMs, the Enrons of the world, etc. And what happens in many of those publicly traded corporations is that you have large number of shareholders. No one shareholder owning any particularly large percentage of shares. You invest that way to obviously make a return as a shareholder. But those shareholders are too small to closely watch how the company is being run, as opposed to like a family-run business where everyone's watching what's happening in the family. And so what we have in our publicly traded corporations is those who manage the company, the board of directors and officers, and those who own it, the shareholders. And the problem in that situation is a problem that the shareholders are not going to get actively involved in watching their investment. They rely on the directors, and particularly we'll talk about the independent directors, to monitor and watch how the business is being run. Now there's a tension that you study in corporate law between the need for the shareholders and owners to watch the managers, and the need for the managers who run the company to have flexibility and freedom to take the risk that business is all about. This is one of the major tensions of corporate governance and one of the major tensions you see in a corporate law course. There's a variety of mechanisms and rules and laws out there and markets to deal with this governance issue. Again, what's the governance issue? Making sure that the managers are doing their job and protecting investors, but not letting the investors get too involved in the managing of the business. And what Enron raises is a lot of questions about corporate governance. Now again, we start off with the board of directors. They're the key role played in the management of the business. But the reality is the publicly traded corporation, many of the board of directors are outside directors or independent directors. They don't work full-time for the company. And they're there to basically watch the insiders and to monitor the business to some extent. But the reality is the business is run by the insiders, by the officers, etc., and the inside directors. And so that there's a limited role that a board normally plays. I mean, Professor Carmel actually served on a board and served on an audit committee of a board and knows that they meet, but they don't meet that often. But they're there to monitor. Now, why do we have most publicly traded companies have outside directors? It's not really a legal requirement, except that the markets require some independent directors, but they're there to protect the public shareholders. And the directors, both the inside or outside, are subject to certain legal responsibilities. Fiduciary duty is one of the more important ones under state law. If they violate their fiduciary duties, they will be liable in a variety of potential lawsuits. The two primary duties you study in corporate law is the duty of care and the duty of loyalty. The duty of care basically asks, are the directors monitoring and keeping informed and acting as a prudent person would in similar circumstances, basically non-negligently. The duty of loyalty really deals with self-dealing and asks the question that if there's a self-dealing transaction between an officer, director, and his company, is it fair and is it fully disclosed? So given that quick background of a four-credit course, I will suggest to you some of the issues raised by Enron. One key issue is the role of the independent directors on the board of Enron. Were they independent? Did they have other relationships with the insiders that made them not so independent? At least one director, Wendy Graham, wife of Senator Graham, who served on the board, was an independent director. She served on the independent audit committee that was supposed to deal with the auditors. Well, the funding for her center at George Mason University came from Enron. Is she independent? Yes, under the rules. Should she be? Probably not. Did these directors breach their duty of care? Did they fail to monitor the activities and watch what was going on? Did they put a system in to make sure that they would keep informed? These are the kind of questions that Enron raises. You're going to hear responses, you already do if you watch the testimony, I knew nothing. This is the ultimate response. It's often called the Sergeant Schultz response from, if you ever watch reruns of Hogan's Heroes, where he would always say, I know nothing. Well, that may be true, but knowing nothing isn't always a defense, particularly if they should have known. Particularly if there were red flags indicate they should have known. They're going to say, I relied on lawyers and accountants. Well, they can rely, as long as it's in good faith. And they have no doubt that the advice they're given is in good faith. So that's going to be the question for particularly the outside directors and some inside directors. What did they know? When did they know it? What should they have known? And is the system really currently, legally and otherwise, the right system for finding out these kinds of frauds? Even if they're liable, there may not be, for their violation of duty of care, they may not be liable for damages, because a lot of companies have provisions in their certificate of incorporation that says no monetary damages for liability, duty of care cases. So that's an interesting question. Within the board, there's this audit committee, as Professor Carmel may talk about a little bit. They're supposed to be made up of independent directors. They're supposed to deal with the accountants on the financial statements. Did they here? Did they overly rely on the accountants? What kind of attention should they have played or should play is another question. Some of the off-balance sheet partnerships described by Ted were involved with not only outside companies, but some of the direct officers of the company had interest in those partnerships and made a lot of money on those partnerships. Those raised conflict of interest issues and disclosure issues. The role of the accountants, again, Professor Carmel will talk about. Did they protect the public here, or were they looking out for their own interests? Will insurance policies pay for some of the litigation expenses? Most companies have insurance to cover litigation when their officers and directors are sued. Problem here is most of that insurance doesn't get paid if you're committing fraud or if there is self-dealing involved. The payment of large salaries raises questions, particularly bonuses and salaries while the company was in trouble. It raises some fundamental questions of what the board knew when they granted these and whether they should be permitted or whether we should do something about these salaries. Stock options, the ability of insiders and officers, in some cases directors, to buy stock at a fixed price. And so if the market price keeps going up, they have the fixed price that they could buy it at. So if they have an option to buy stock at $30 and the market price goes to $60, they can convert that option to a $30 profit, basically. There's a lot of compensation in stock options. Did that drive the insiders and directors to fraudulently inflate the value of the company's stock so they could cash in their stock options? Is a question raised by Enron. And does stock options subvert the way directors run their companies to try to push the price up so they can benefit illegitimately? Did employees and insiders who sold their shares when they knew the company wasn't doing well, did they violate insider trading rules? Well, I think the answer is probably yes, but we have to find out what they knew and when they knew it, etc. But there are questions about that. Should directors and officers involved in misleading statements be liable, and to what extent? I think President Bush, I don't think anyone would call him Professor Bush, but anyway, I may get a judicial appointment out of that. President Bush has even proposed that if officers and directors are involved in issuing misleading statements, they should give back their compensation. Something unheard of, I guess, from a Republican president. Anyway, what does this matter? Because so many Americans now own shares, and financing of our business depends on the trust of public investors in buying stock. If, in fact, Enron represents more than Enron, it makes you question whether you should invest or not, and how much you should invest, and what risk there is in investing. And as a result, the Congress, the SEC, and others are looking at ways to deal with this question. Okay. Next on the list is Professor Carmel on accounting issues.
It's nice to have so many people here, and it's very flattering to have standing room for such a technical talk. But there really are plenty of seats in the first row, the second row, the third row, and even over there on the couches. So you don't need to stand in the back. Come and sit down. I'm going to talk about the SEC's regulation of the accounting profession, and in particular, the SEC's regulation of auditing. I wrote an article about this for the New York Law Journal that is in the handouts that you should have received when you came in today. So I'm going to give you just a summary of what's in that article. If you're interested, read the article. The SEC, Securities and Exchange Commission, has been given the power to set accounting standards. Accounting standards are the rules that have to be followed in the presentation of financial information by companies, and particularly by public companies. I'm also going to talk a little bit about auditing standards. Auditing standards are different from accounting standards. Auditing standards are the rules that have to be followed when accountants inspect the books and records and financial statements of public companies and decide that the information in those statements meets generally accepted accounting principles, and then auditors certify that those financial statements have been correctly prepared. As I said before, the SEC has been given statutory authority to establish accounting standards. It has actually delegated much of this authority to the Financial Accounting Standards Board, called the FASB, which is a private sector organization funded by the accounting profession. It is a very ivory tower organization, meets up in Connecticut in a very woodsy area, and thinks about what accounting standards should be, and has hearings on various proposals, has a continuing continuing dialogue with the SEC, and after Enron has been severely criticized for a number of standards that it has passed and a number of standards that it has not passed, particularly standards having to do with those SPEs that are there on the chart. My personal opinion is that some of this criticism is really unfair because the SEC can always override the FASB and pass standards of its own, and it has occasionally done so. And in addition, one reason that the FASB is very slow and deliberate and often has no backbone when it comes to putting in difficult standards is because it is lobbied by Congress on behalf of public companies that would not like to have particularly strict accounting standards. After Enron, I think there will be some change in the dynamics between the FASB and the SEC, and there are some bills that have been proposed in Congress that would actually change the funding of the FASB to make it a more independent body. The Center for the Study of International Business Laws is one of the sponsors of this event, so I'm going to mention something international. There is an organization called the International Accounting Standards Board that's in London, that's like the FASB, except it sets standards on an international level. For many years, the SEC has refused to accept in SEC filings financial statements prepared according to international accounting standards and has said only U.S. GAAP, U.S. Generally Accepted Accounting Principles, is good enough for the SEC. There's now been a lot of chit-chat in certain circles of, oh well, U.S. GAAP isn't really so good as everybody thought, and maybe the International Accounting Standards Board, which is now headed by Paul Volcker, the former head of the Federal Reserve Board, will really come out in front of the FASB and come up with more rigorous standards. Let me turn to auditing. The SEC actually lacks statutory power to establish auditing standards. Auditing standards are set by various organizations that are arms of the AICPA, the American Institute for Certified Public Accountants. The SEC does bring disciplinary actions against accountants if the SEC believes that the accounting firm has engaged in audit failure or is not independent. This is the one area having to do with auditing in which the SEC has specific statutory authority. It can define independence for purposes of determining whether or not an auditor has been independent, and only independent auditors can certify financial statements. There's a big controversy because of Enron over the combination of consulting and auditing in auditing firms. This controversy goes back several years. The last chairman of the SEC, Arthur Levitt, tried to pass a rule to prevent accounting firms from combining auditing and consulting. He was only partially successful. People say, or there are critics who say, that one of the problems with respect to Enron is that Enron's accountants were doing a lot of consulting for Enron. They were not just doing auditing, and the desire to get consulting business from an audit client makes the accountant less independent. There's now great scrutiny by public company boards and their audit committees as to whether or not they will permit their auditors to get consulting contracts from them. A new public organization for accountants has been proposed by the SEC and in various bills that are now pending in Congress. It is thought this board should be composed of 2/3 independent directors, that is, directors who are not part of the accounting profession, and that this would improve the accounting system. Also that this board would have power to impose sanctions for violations of independence, ethics, or competence, and that this board could review the audit work product of auditors and conflicts of interest, and it's hoped that such a board will have real teeth. There are various other ideas. Maybe we can talk about some of them in the question period. Enforced rotation of auditors and selection of auditors by the SEC, or at least the audit committee, rather than the management of public companies.
Thank you, Professor Carmel. Professor Ziegler is going to talk about some of the lawyers' issues, and there are plenty of lawyers' issues in this case.
Good afternoon. It's sort of a pleasure as a lawyer, and particularly as a teacher of legal ethics, to have the attention focused, albeit just temporarily, on accountants. Indeed, is it possible that we'll dodge this bullet and that we can look forward to a slew of accountant jokes dominating the airwaves? Well, I wouldn't count on it. But although Enron does yield numerous examples of lawyers behaving badly, and I'll briefly talk about just some of them, it's equally important to note that some of the criticism that's been leveled against lawyers is structural. That is, it is for conduct that the ethics rules, as we understand them, in most jurisdictions, and the rules that have been adopted by the American Bar Association, not only sanction the conduct that has been criticized, but require it in some instances. And I want to spend a little time on that, because it seems that no matter what happens with Enron, those issues will persist. Just by way of a little bit of background, for those of you who haven't taken legal profession or can't remember it, what bad things can happen to lawyers who break a variety of rules? Well, many bad things. Here are some of them. Of course, lawyers are subject to criminal law, all right? And may even be, if their conduct rises to a certain level, subject criminally for conduct they undertake in representation of a client. So put that to one side. Second, lawyers are subject to malpractice and breach of fiduciary duty liability, not only in actions by their clients against them, but in some instances, particularly in the securities area, in actions by non-clients or third parties who are injured on account of the client's frauds which the lawyers may have facilitated through their legal advice. Okay. Next, and it's not really directly related to the subjects I'll cover, but there are litigation sanctions. You can get disqualified, you can get fined. Bad things can happen to you there. And finally, there's professional discipline, as in having your license pulled, or other unpleasant sanctions like censure or suspension from the practice of law. Keeping all of that in mind, I'd like to talk about two sets of lawyers. The first are the firm of Vinson and Elkins, the Houston law firm that has long represented Enron, and did represent Enron in issuing true sales opinions concerning the off-book entities that Professor Janger told us about. Not only did, and let me just stop for a second. Insert allegedly everywhere you think it ought to go, because the truth of the matter is that we don't know really what happened yet. I've read the newspapers, perhaps you've read the newspapers, perhaps I've read more of the newspapers than you, but nevertheless, this is all based primarily, really, it's based on journalistic reporting. And we don't really know all the facts, nor do we know whether all the facts that have been reported are true. Okay. And the public service announcement. Okay. So, Vinson and Elkins issued opinions, attesting essentially to a legal opinion that the transactions that we've discussed did indeed constitute true sales. Okay. Vincent and Elkins then was retained after Sharonette Watkins came forward and made allegations about these very accounting procedures and disclosure or lack thereof. They were retained to investigate those charges. So many have alleged that essentially Vincent and Elkins was retained by Enron to investigate its own conduct, at least in some regard. This is without taking professional responsibility, you can know this one when you see it. This is a conflict of interest under any definition of the term. It should come as no surprise, therefore, that the two-headed Vincent and Elkins is now facing the possibility of major malpractice liability. Although liability for opinion letters is generally doubtful. But this is not your usual case. And depending on what the firm knew about Enron's financing schemes overall, Vincent and Elkins may not only find its reputation tarnished, but its coffers significantly depleted. Okay. Second, Vincent and Elkins has been criticized because it didn't disclose information in its possession that might have prevented or mitigated its client's fraud. Most astute observers have noted that the firm's failure to disclose was the product of the ethics rule regime that prohibits lawyers in most jurisdictions from making such disclosures which would breach lawyer-client confidentiality. Indeed, I looked up the pertinent provisions of the Texas ethics rules. I should have known something was up when a slew of former clients started calling me late this summer, asking me about arcane provisions of Texas ethics law and disqualification law. I had no idea until after the fact that out there in the country are your fellow future alums are out there now practicing who somehow were involved in this some way. But foolish me, what did I know? I said, Texas? I don't know anything about Texas. Well, I did look up the Texas rule. It calls on lawyers who gain information that their clients are engaging in questionable or fraudulent activities to urge their clients to, quote, take corrective action, period. Nothing in the ethics rules requires nor permits lawyers to disclose this kind of information. This isn't only true in Texas. This is true in most American jurisdictions. After Enron, or after the beginning of Enron, an editorial in the New York Times called on the American Bar Association to reconsider a proposal, an amendment to its model rules that would have permitted lawyers to disclose where their services were used to perpetrate this fraud, even if they didn't know it at the time. Their services were inadvertently or mistakenly used. That proposed amendment was defeated last summer by the ABA's House of Delegates. And this is not the first time that such a proposal has been defeated. It's been brought back like the Wizard of Oz every 7 years or so, and defeated. Many prominent lawyers, some of whom were influential in defeating the ABA proposal, argued that defeat of such proposals was absolutely the right thing to do because lawyer whistleblowing, they argue, is inconsistent with the very foundation of the lawyer-client relationship. Put in other words, lawyers are not accountants. Lawyers don't have the kind of public function that the auditing accountant has in certifying information to be true, and that lawyers' obligations may require keeping this very kind of information secret, even though others will be harmed. It's the client's interests that the lawyer, this argument goes, is charged to protect, not those of third parties or society generally. Of course, nothing in the rules would have prevented Vincent and Elkins from withdrawing from this representation, but hey, okay. Finally, a word about the lawyers at Arthur Andersen, the lawyers inside the accounting company who allegedly authorized their employees working on the Enron matter to destroy thousands and thousands of pages of documents and email transmissions having to do with that work. Now, all companies have, quote, document retention policies. It means you get rid of paper and communications after a certain period of time. Nothing wrong with that. In fact, you can't function without such a policy. But as in this, as in life, timing is everything. And you may be interested in knowing that it was on Friday that the lawyer issued permission to do this wholesale house cleaning, and on the following Tuesday that Enron wrote down its net worth by $1.2 billion. Coincidence? Well, perhaps. No subpoena had been issued yet, and what's interesting, I think, here is that if they thought about it, the lawyers may have concluded that until a subpoena was issued, they could shred away. Not so. Can you spell obstruction of justice? Well, those are very complicated statutes, which I will not try to explain here in the minute, less than a minute that's remaining to me. But lawyers who think that the subpoena is the magic moment after which the constraints apply had better think again, because I think they're going to find out very quickly that that's not so. And that with this investigation looming, and them knowing the roof was about to cave in, an investigation almost inevitably would follow. I hope they can spell obstruction of justice.
Thank you, Carol. Jim Fanto will talk about briefly about some banking and investment banking issues.
Yeah. You put on that slide that big Enron's? Yeah, that one.
This one.
Okay. Now, I'm just going to talk briefly about the Enron and the financial system, and Enron and financial professionals. And that, if you think what allows a financial system to work, or what is a financial, what are we talking about? We're essentially talking about companies. How do companies raise capital? For their operation, if they're not doing it, from their operation itself. How do they get it from outside investors? And I think we say that there are really two ways, two rough ways they do it. They do it either through, directly from financial professionals, generally banks. They get it intermediated in that way, investors to banks, to the companies, or they get it through a market system. Okay, that's really what capital raising is about. Get it off the market or through financial professionals. And when you look around the world, you say, well, what's a country like? Is it a market-based system, bank-based system, a combination of the two? Now the United States is primarily a market-based system, although with, heavy bank involvement. Now you ask yourself, what makes that system run? Well, you often say, well, what makes it run is the financial professionals. That they make it run. And people often talk about them as gatekeepers. Well, what does that mean? It means, well, they identify for investors what are good investments to make, and they help companies raise capital. So they help companies identify investors for themselves. So, they're really the go-betweens. So, if you think about what we have, well, we have banks providing capital, and banks are intermediaries, that we deposit money with banks and they invest it for us, usually as creditors, and Ted has creditors up there. Or you could invest through the market, and then you say, well, who are the financial professionals there? Well, they're your brokers. Generally, you're talking about investment banks that help you identify companies to invest in, or help the companies raise capital from the markets. And there he has up there shareholders, or also outside investors.
Right, and those are the two places where the markets are operating.
Right, where markets are operating, and creditors, that can be some market-based too. Well, I think one big issue with Enron is, why didn't those financial professionals know that there were all these problems in this company sooner than they did? Because ultimately they did. They said, hey, there's a big problem, and you should sell your shares. Of course, the price is down like $1, so it didn't help. But or the creditors tried to call in their loans, but they're in the bankruptcy proceeding trying to get money. You say, well, why didn't they do that? Why didn't they notice earlier that there was a problem? Now that question is particularly acute for banks, because historically, people have thought of banks. Well, banks are kind of hard-nosed. They lend money. They're very suspicious. They may really pull money out at a particular time when things start to smell bad. And then why didn't the banks and Enron do that? So a lot of what's talked about now, or at least an issue that's raised, is they say, well, why didn't banks do it? Why didn't the J.P. Morgans of the world, really one of the most reputable banks you could imagine, maybe before it linked up with Chase, why didn't they, pull a plug much earlier? So that's one question I think that's out there. Now, some people have said, and then a related question, well, why didn't the investment banks do that too? Why did, was there a hole, with investment banks say things like, should you sell your shares, buy more shares, or hold? They never say sell. But hold is a very bad sign. Why did the hold message come through at the very end with respect to Enron? And very late in the game, all the investment banks were saying, buy more. So why didn't these gatekeepers work? Well, if you think about, and these are larger questions, because if the gatekeepers don't work, if the banks don't work, they suffer, they won't recover their money, and they may go down and draw us all down with them. And if the investment banks aren't doing a good job, then we just lose confidence in them. We go back to putting our money, in our mattress, or in hard assets. I mean, don't laugh. Just so I don't trust them, start buying gold, or just things that I can hold. Because otherwise, why give it to these people? Just waste it. That's a question I think that's before Congress now. People have been talking about as a bank-specific question. Some of the talk says, well, banks really didn't do their job because they've been getting into activities that are much more not their traditional activities. They're much more involved in investment banking activities. In other words, the banks, they may have been creditors, but they were also making a lot of money helping shareholders invest in Enron, or helping those outside investors invest in those special purpose enterprises. In other words, the banks were getting a great amount of fees through these investment banking activities. So they were conflicted. And they said, well, that happened really because of a change in the law that's been going on for over 20 years, and finally happened in 1999 that allows banks to do investment banking type activities. So some people, you may see this raised, was that a good change in the law? Should we push banks back to their narrow activity of just lending, which will be a benefit for the financial system? Now, on the investment banking side, no one's ever liked investment bankers. I mean, we know them because a lot of our parents or friends, do investment banking. But, and we're in New York, so we appreciate it. But a lot of people don't like it. And And so you have to ask, well, what's wrong with investment banks? Why didn't they notice the problems? And a lot of the question is, why didn't the people who recommend to us investments, and they're often under the research department of investment banks and they're called analysts, why didn't they see the problems? And it's been alleged, well, maybe they did see the problems, but they were making so much money themselves from helping Enron raise money that they had no incentive to pull the plug or call attention to the problem. So those are, some issues that are out there on financial professionals.
And the cleanup hitter is Professor Poser, who will take us to the end of the program and open up for your questions on litigation and legislative responses.
Thank you. So litigation, maybe that's the cleanup, right? And legislation. And with the head of the General Accounting Office, the investigating arm of Congress, when he originally threatened to sue Vice President Cheney because they weren't giving up the documents of his meetings with the energy people with Enron, and there was a lot of publicity and spinning came out of that. He had 3 words which were very good: talk is cheap. Then he sued. So now we're going to clean up the mess. Many securities suits have been filed, as you probably know. Also suits under we haven't talked about the pension side of this at all. Fact is that a lot of people, including employees, have lost money, and that may be, in a way, the most politically charged part of this, the employees. But let me just first talk about the securities suits. A number of them are class actions by persons who bought Enron stock in reliance on false statements made by Enron about its financial position, in reliance on the thought that the market for Enron was an honest market, which it wasn't. And quite recently, the Federal District Court in Houston has consolidated the class actions and appointed a lead plaintiff for these cases, as they're required to do by the law. This is the Board of Regents of the University of California, one of the biggest losers. I saw, by the way, that TIAA-CREF, which is or CREF, which is the College Retirement Equity Fund, where my colleagues here and I, all our pensions, and Professor Hellerstein's pension, they, as of December 31 of 2001, they owned about 4.5 million shares of Enron, worth something less than $4.5 million, maybe a few $100,000. However, this consolidated class action, these are people who bring lawsuits on behalf of a class of people. This is a class of people who bought Enron stock. The Milberg Weiss law firm, which is I think the biggest plaintiff's class action law firm, at least in the securities area in the country, has been appointed lead counsel. And this could be, talked about the largest bankruptcy, this could be the largest and most complex litigation of its kind in history. Class action suits have been brought, or they now consolidated, against Enron Arthur Andersen, the Enron executives, investment banking firms. Buyers of Enron have sued, including the class actions and other suits I'll mention in a minute. They've sued Messrs. Skilling, Lay, and Fastow, 3 top people at Enron, for trading on inside information of Enron's financial condition at a time when the financial condition wasn't publicly known. I might point out to you that a contemporaneous purchaser, that is when insiders are bailing out, when the rats are deserting the sinking ship, the purchaser, who's contemporaneous, not clear what that means, but around the same time, can sue. But that's not terribly comforting, because under the law, the recovery is limited to the gains by the insider from his insider trading. Well, if you think about that, however many millions of dollars Fastow and Lay and Skilling, if they allegedly did it, if they made it, it's a drop in the bucket compared with all of the losses, billions of dollars of losses. There won't be enough to go around. Institutional investors, like investment companies, mutual funds, insurance companies, have brought individual actions against investment bankers, the people who Professor Fanta was talking about, for arranging financing for Enron. In one case, Enron, in one case, there's a Canadian investment company sued three firms: Salomon Smith Barney, which is owned by Travelers, which is big insurance securities conglomerate; Goldman Sachs, which some of you may have heard of; and Bank of America, for fraud, negligence, and violation of a section of the Securities Act, which is basically a negligence section. What happened was this. Sometime last year, Enron sold some debt securities, there were notes, to these things that aren't sold by you and aren't bought by individual investors. They're bought by these large institutions, the investment companies and mutual funds and so on. And this was an offering of securities where Enron is going to the public and asking for financing. Well, we have some special laws there. And Section 11 of the Securities Act of 1933 says that an underwriter, that is, one of these investment banking firms that goes out and helps these people, helps Enron sell its shares, is liable unless it performs due diligence. That is, they've got to make an investigation of Enron. Well, these firms that I mentioned were underwriters. And let me just show you what some of the things they were saying in late October of 2001. One of them said that Enron's a strong buy, the best of the best. This is October. I'm talking about three very important firms. I just named them. Salomon Smith Barney says, cash flows appear solid over the balance of the year. That's 2001 they're talking about. So you've got problems here, and these people have problems. Because unlike the securities, the securities fraud, where you've got tremendous hurdles to overcome, and I'll just mention a couple of them in a minute. All you've got to do, I'm out of town? Ooh, all right. Well, a lot of people have lost money. Let's assume that you were smart enough or dumb enough to buy Enron 3 or 4 years ago, or your rich uncle left you a bunch of Enron stock. And you have a broker, let's call it Salomon Smith Barney. and they say to you, hold. That's what Jim was talking about. Absolutely. Hold. So you hold, and Enron goes down to nothing. You can't sue them, because you can only sue if you bought the stock. You can't sue for hold. They can't sue because you held it. You've got to be a buyer or a seller. Justice Rehnquist gave us that 25 years ago. He was afraid of vexatious litigation. And so only a buyer or a seller can sue. Another problem is that Enron, if you want to sue Enron, well, they're in bankruptcy. And let's assume you are completely successful and you get a judgment against them. Well, line up with the other creditors. But let's go to the deep pockets. Let's go after Anderson. Let's go after those investment bankers. Let's go after Vinson and Elkins and so on. You have a hard time because the Supreme Court in 1994, Professor Hellerstein and I heard the oral argument, said that there's no such thing as aiding and abetting securities fraud in a private suit. So you're out of luck there. It's going to be very difficult. I just want to mention, part of my talk was legislation, but I'm out of time. I will mention just this, that the aiding and abetting question, that is, being able for the private plaintiff to go after the secondary person, the aider and abetter, there is legislation in Congress to change that, to reverse the so-called central bank case that said there's no aiding and abetting liability. But I will finish up by quoting Otto von Bismarck, you all know about. Otto von Bismarck said there are two things that you don't want to see how they're made. The first is sausage, the second is legislation.
There were many other faculty who we could have asked. Sitting in the back is Professor Gerber, who volunteered to talk about bankruptcy issues, and Professor Gora, who volunteered to talk about campaign finance issues, and I'm sure Professor Hellerstein would have talked about corporate liability, etc. But we had to fit it in. Well, maybe he would. Anyway, so we're open for questions now, and are there any students first who have a question? Go ahead. Student first.
What did they eventually see happen? These managers of Enron, how did they see this situation correcting itself? Because it seems, I'm a little bit less confused now, but it seems like it's something that just...
Well, a quick answer to my point is hope. Hope springs eternal. I think to some extent they all felt that the business was in sort of a downturn, generally that we were getting into a recession, but at some point the business would pick up again, that their broadband strategy, one of the strategies, would pay off, etc., and that they could cover it up with more revenue. That's my answer.
Bankruptcy lawyers have a name for that. They call it the terminal optimism of the doomed. A lot of times, a business, when it sees its business going down, will say, well, let's just buy some time. And they'll do some pretty desperate things to buy some time, because if they pull the plug, they're out of a job. So you do a little bit, you do a little more, you do a little more, and that initial faith that it's going to turn around turns into a desperate hope that it's going to turn around. It turns into a desperate hope that it better turn around or you're going to go to jail.
It seems compulsive. I mean, all these corporate or partnership that they were forming.
Compulsive is a good word. There were hundreds of these. Wasn't there maybe of these types of things?
883.
How much?
883.
883. Actually, Professor Daniels will talk about tax issues here. There were 883 of these things.
They were all foreign.
And they were all foreign, that's right. So if you couldn't hear it. They were all set up overseas. Now, as Professor, what's your name again? Janger suggested, a lot of these transactions, and Professor Zanetta, are sometimes legitimate to do these things. So it's not just illegitimate to set up a special entity and whatever. They have legitimate purposes, finance and otherwise. But the number here, arguably, could have raised some red flags. Definitely, yes.
It's for Professor Carmel.
Professor Carmel. I'll repeat the question so they can hear.
Oh, sure. I'll be loud enough.
Okay.
You mentioned there's two sets of audit. One is the SEC audit, and the other one's regular audit for the Arthur Andersen. I think there's tremendous overlap there between the Arthur Andersen audit or like regular accounting audit with the SEC audit. Do you think there might be a tendency in the future that the SEC audit will just take the role of the regular accounting audit?
I think it's a misperception there. Okay.
Yeah, the question was about SEC examination, really, of public company filings and audits by CPAs. And I think that there is a widespread misconception about this. I mean, in fact, the FCC never examined Enron's annual and periodic reports for some of the periods in question here, The SEC does not examine all reports filed by all public companies. The SEC examines registration statements for initial public offerings. During 2000 and 2001, the SEC was so busy examining reports for companies that were making IPOs that the staff did not have time to examine the reports of companies that were making annual and periodic reports. There's been a lot of criticism of this by Congress, but at the same time, Congress does not want to spend the money to beef up the SEC staff or pay the SEC staffers any more money. In fact, Congress recently passed what was called a pay parity bill to raise the salaries of SEC staffers to the level of that staff that other financial agencies like the Federal Reserve Board were getting. And then the Bush administration has refused to allocate the money for this. So there's a problem there. Whether there'll be changes, I don't know. I mean, there are a lot of suggestions for change in Congress, but it would cost quite a bit of money, and there's a reluctance to allocate that money.
To make it clear, the SEC doesn't audit at all the books. They will examine the filings. The auditors are the ones that go out and supposed to see that the statements fairly reflect the information. So the auditing is the checking process they go through. It's a different process, two different processes.
So basically, the auditor can never be independent because they're being hired by their client.
No. Let's make
Some
this.
people say that.
Yes, it's always on Congress. The reality is, after the stock market crash of '29 and the passage of the securities laws in 33, 34, it's crystal clear that all accountants are supposed to be independent, and their duty is to the public investor, not to the company, as opposed to the lawyer who's hired to represent as an advocate for the company. Two different roles. Supposed to be, whether they are or not, that's one of the questions given the events of Enron. Yeah.
Given what we know already, can the board of directors be brought up on criminal charges, or can the...
The question is, given what we know, can the board of directors be brought up on criminal charges? Well, I don't know if I want to answer that because I don't know enough about it. We don't know enough at this point. The outside directors, doubtful, highly doubtful. It's a rare case. The inside directors, officers, they're the ones more obviously that can have a criminal indictment, but I don't know enough about what they did to whether it borders on criminal. It may border for whether it reaches criminal. Anyone else here have a...
It's very unlikely, I would say.
I'd say very unlikely. It's so rare that that you go after the officers. There's a famous case years ago, GE price-fixing case in the 60s, where the people that went to jail were the lower-level employees because they kept the blinders on the officers. But I'm not sure about that. How about in the back? Way in the back. Go ahead. Shout it out.
There's a lot of talk now about how Arthur Anderson is looking to enter in some sort of combination with other accounting firms, not necessarily mergers, but maybe purchase of his assets.
Right.
Given that one of the purposes, in addition to continuing performing various audits and other engagements, is to limit its liability, how will the SEC and other boards look at this potential combination of sale of assets? Do they allow it to go through? This could have a limiting effect on other...
Well, he's talking about the issue of, in the paper, I think it was today, whether Arthur Anderson may be acquired or they may sell its assets off to another accounting firm in order to survive, basically, in some ways, and get rid of potential some of the liabilities. And the question is, how's the SEC going to look at this issue?
The SEC probably has no ability to prevent that from happening, but the SEC has tried, or did try, to involve itself in encouraging a kind of global settlement of Anderson's liabilities to really keep Anderson in place. The problem is there's only 5 big accounting firms. That, in my opinion, is not enough. You have an oligopoly to begin with, and if you go down to 4, and you have this idea that one of the problems is there's not enough rotation by companies of auditors, and you just have 4 big firms, well, even an enforced rotation is not going to accomplish a whole lot. But this is really a problem for the antitrust division of the Department of Justice, and not the SEC. And they have never said anything as the accounting firms consolidated.
It's not clear. I mean, I think that Roberta is right that the issue of the sale or the consolidation of Anderson is a competition issue, not a somehow the sale of assets is bad for the creditors of Enron issue. One of the things the story in the paper today said was what they're fighting over now is what they're going to do about the potential Enron liability as part of the consolidation. And so long as that's kept, you know, whatever assets would be there for the Enron creditors stays there, then the fact that the business, the Anderson business of accounting, goes somewhere else isn't necessarily a problem.
There's actually some talk that Anderson may have to go into bankruptcy to avoid the liabilities and transfer the assets free of the liabilities to the other.
And let's see if this LLP statute's any good.
Another question. Yes. Go ahead.
In terms of the SPEs and like what the policy was behind them being developed and why they're allowed, I mean, such a high percentage before they're even forced to be put on the books. I mean, what was the policy for that?
Gosh, I wish I knew. There is a legitimate purpose behind structured finance vehicles. It's a pervasive business. There's a $6 trillion industry out there in securitization of assets or asset-backed securities. And one of the nice things about it is that you can mortgage your house cheaper, you can mortgage your car cheaper, and so on. The transaction itself isn't necessarily a problem. Indeed, there was some recent, there were some provisions in the bankruptcy code that just got taken out because of Enron that would have made it easier to set these things up and to beat the bankruptcy estate. What seems to me is the trouble is the rules for off-book accounting of these entities. The entity itself isn't necessarily a problem. The problem is whether the balance sheet you look at is Enron with the entity or Enron without the entity. And the off-book accounting rules, how they got the way they were, I'm not entirely sure. I'm not an accountant, except to say that it was expensive, people wanted to do these deals, and I suspect there was pressure to say, this is good, this is good, this is good, and eventually they got to the point where a lot of it was good, but a lot more of it might in fact be bad.
Well, how will that affect the litigation in terms of it being a legal vehicle?
It's a problem. It's a problem to the extent that, to the extent that Enron was pushing beyond the envelope of the FASB rules, that there may be liability on the accountants. To the extent that Enron was within, there may be a lot of these partnerships that turn out to be legitimate. The same thing for Vincent and Elkins on their true sale opinions. The true sale opinions were probably, well, I'm sure they were 20 or 30 pages long with lots of qualifications that said, we're assuming this, we're assuming this, we're assuming that, and this might happen and that might happen. And so long as they said all of those things, the fact that the true sale then later gets unwound isn't a problem for Vincent and Elkins. The problem that Vincent and Elkins really has is, one, that they audited their own transactions. Two, they might somehow be linked to the fraud if they knew that some of those assumptions weren't true. And three, and this is a policy point, it's not clear to me that the rating agencies that looked at these opinions understood what all of those qualifications meant.
Well, what they would have to show, at least to show fraud, is they have to show that Vincent and Elkins, or whoever we're talking about, or Anderson, actually made false statements or kept true statements off from the public, and that one might be very difficult to show that they actually engaged in fraud as opposed to helping Enron. It's possible that under some state lawsuits involving, for example, negligence or common law fraud, they might possibly be able to, a plaintiff might be able to succeed, and those kind of state common law suits have been brought, but even there you have different states with different doctrines as to who, let's say, an accountant owes a duty. Do they just owe a duty to their client, or do they owe it really generally to the public? New York law says, famous Cardozo case says that an accountant, Ultramaris is the case, said that an accountant only owes a duty to its client.
Not to the public or third parties.
I guess I have a couple of questions, kind of narrow them down here.
Take one at a time, the first one.
Yeah, right. One is, I guess, I think it was mentioned that Skilling, Lay, Basto, are they going to be held responsible in any way? And if not, how does that, what kind of message that give to other corporations that are probably doing the exact same things that Enron, the one that got caught, or similar situation with pushing the envelope, and nothing happens until it explodes, and then there's no penalties.
There's a lot of different. One thing, I would think that if other corporations are doing this, and let's hope not too many are, they have stopped doing it, or they have made. I mean, one thing, the lesson here is, at least for now, let's clean up our act. On whether they're going to ultimately be liable under a civil or a criminal, it's an open question. They're clearly been tried in the court of public opinion to some extent, and Watkins is right now the hero, and the others are not looking so good in retrospect. But they're in denial also, and we've got to show something more than, particularly a criminal action, we've got to show something more than this all happened under your watch. It's not going to be enough.
Can I just add one thing to that? What I said before about, say, Anderson doesn't apply to these people because I don't want to get into the criminal law, but under civil law, they could be, it's pretty clear that they control Enron. And if Enron is liable under, say, the securities laws, which it very well might be, then they are probably liable too, and are personally liable as controlling persons.
And I wouldn't be so sure as Professor Pinto is that none of these people will be criminally prosecuted. I mean,
I wasn't sure, I just don't know.
I don't know either, but I mean, some of them have already claimed their Fifth Amendment privilege, which means that at least they have been advised by lawyers that they are in jeopardy. That doesn't mean they'll be indicted or convicted, but there have been many people who are indicted and convicted under the securities laws for securities fraud.
And for insider trading.
And this is more serious than insider trading, so it's certainly a possibility.
I know this is a situation with, I don't want Martha Levitt making a big push to really try to, regulate the accounting firms, and then that kind of had to compromise.
Right.
Now that you have Harvey Pitt there, he's kind of saying, things are kind of good the way they are, but now they're talking about this independent accounting board. What is the significance of having that independent accounting board? What is he?
I think that the difference in what's being discussed in terms of this independent accounting board is that it would not be solely financed by the accounting profession, by the AICPA, and it would have a majority and perhaps even 2/3 of its board of directors not coming from the accounting profession. Probably it would also have statutory oversight by the SEC, whereas now the AICPA does not have statutory oversight by the SEC. So the SEC can do a lot of jawboning, but it can't really alter a lot of what the AICPA does.
But this group would really look at how the accountants are doing their job, basically. The other issue is whether accountants should wear 2 hats in a company.
That's right.
The other,
It's a different
Arthur
issue.
Levitt, is a different issue, where Arthur Levitt said, we don't think accountants should be auditing the firm at the same token providing consulting services, and that was didn't get through congressional opposition, et cetera, and now it's been revived again, and we'll see what happens to it.
Arthur, one point on the civil liability point, which is most of these people live in Texas, and Texas at present has an unlimited homestead exemption. So to the extent that they own less than, I believe, 10 acres in a city or 240 acres in rural territory, they get to keep all of the land and improvements.
In other words, if they're forced into bankruptcy by the judgments, they get to keep their house, which wouldn't happen in New York.
Very fast grab.
Yeah.
I was wondering if you expect there to be any changes in the laws or the rules regulating investment banks?
Well, Jim has to go off, and You can,
I really don't think so. I don't see it happening. I've looked at quite a lot of legislation that's in the works now. This is entirely unpredictable, first of all. We don't know what's going to come out of this. I think that if we might see some small changes in the securities laws, which I mentioned one possibility of bringing in the aiding and abetting thing, but even that, my sense of it is that if we're going to see changes in the law, it's going to be in the pension area. This is what pushes people's buttons. The fact that you have thousands of people lost their pension funds, and there are laws there are bills in Congress dealing with diversification, not putting all the money into the company's own stock, and so on. I just have a feeling that politically that's what's likely to happen.
I think one area where there could be changes, but probably not by legislation, but more by SEC rulemaking, is in the area of financial analysts and analyst recommendations, and putting various kinds of requirements on analysts to make them more independent. Currently, the self-regulatory organizations have come up with some rules, and maybe that will be the end of it. But it's also possible the SEC will do some rulemaking in this area, saying, for example, an analyst can't own stock or can't buy stock before they recommend it. They can't sell stock before they change a buy recommendation, things like that. That's the only thing that is being talked about right now that I'm aware of.
More disclosure about
More disclosure about analysts' role, that analysts can't get investment banking fees.
What change will happen to the campaign?
The campaign finance law, what kind of changes could this have an impact, if at all, on the campaign finance law? Joel?
Shut up. It's interesting that the one piece of legislation that looks like it's going to pass as a result of Enron, which didn't pass before Enron, is the campaign finance bill. And some of us have real problems with that bill, but if your question is, would the bill have prevented another Enron? I think the answer is no. I think although Enron gave a lot of soft money, they also gave a lot of legal money, and under the bill, the legal money is now doubled. And in some cases triple. So the employees and the officers in Enron could give as much, if not more, money under this reform bill as they could have before. So I'm sorry to say, I don't think the campaign finance bill is really going to prevent another Enron. I mean, I think what Enron is really more about are the issues that the panelists discussed.
A lot of people try to connect Enron, I think.
That's right. And I think, in a way, it's sort of what else is new. I mean, what happens is a bill that has a lot of support is going to be passed, which has nothing to do really with the basic core problem. And the bills that might solve the basic core problem, which is in the jurisdiction of all of my colleagues, are going nowhere.
Right.
So that's what's new.
Well, I was just going to make the analogy between the securities to something that I know about, and that's the way drugs are handled in this country, where we have a panel which is really like these ratings agencies. But that panel is chosen by the FDA. They're outside people. There's some government workers on it, but it's limited. The majority of people from industry and from academia that review it and then make their recommendation to the government, which can license it and doesn't have to license. And the strength of these Moody's or whatever these recommend has grown up. I'm even afraid of it happening that U.S. News and Business is rating law schools, and suddenly we're taking it as seriously as they're taking these rating services. And I think the regulation of the rating services, CalPERS, who is arm in arm with the University of California Regents, because there are other public employees knew all along you dumped because they figured it out, and yet the lead plaintiff can be the closest public institution to them. and they didn't tell them.
And that's
That
right.
would never happen in
You raise a lot
science.
of issues
That
there.
would never happen in science. There would be a scandal immediately.
Well, we know that this point why it's definitely not a science. Back?
Yeah, I've got one quick question on the analyst, because Citicorp's, the very large financial institutions that do the analysis of the stocks are the same ones who the companies go to for the recommendation of their balancing, getting debt and whatever it is.
Right.
There's a tremendous pressure on analysts to come up with good recommendation for the very companies that are seeking funding for those companies. What you're saying they're recommending doesn't do anything. I mean, just limiting the people who are doing the recommendations from buying or selling stock does nothing for the analysis of the actual underlying stock situation, unless there's a firewall put up between these or they're split apart. I'm not hearing any of that.
Well,
There is some of the self-regulatory organization proposals that are pending would prevent analysts from sharing investment banking fees from the clients that they give a favorable recommendation for. But these proposals don't go terribly far.
I was just going to say, I totally agree with what you said, and that Professor Carmel, when she was talking about it, mentioned one aspect of the conflict of interest that analysts have, and you're absolutely right. Owning the shares is one. The structure of the firms is another, which is very important. I think that's what you're raising, and compensation systems within the firms. The problem is that it goes beyond analysts. The problem is that our broker-dealers, which means either brokerage or investment banking, but it means both, our brokerage firms have myriad conflicts of interest, and always have. And it's something that I don't think any of us see this being changed at the present time. It's there. And
I agree.
I don't see any big
If
change.
anything, it's the changes Professor Carmel, or more disclosure, maybe. But even that is inherently in the system. You know, they always talk about the accountants' conflicts now, but you're right to suggest the investment bankers have, and the brokerage industry has major conflicts.
The SEC once suggested that the only way to prevent this would be to allow a broker to either be able to trade for himself or to trade for customers. But if he traded for customers, he could only have one customer, because otherwise he'd have a conflict of interest.
Anyway, one more question and we'll call it a day? We'll call it a day then. Thank you for coming.